Good afternoon, everyone. Welcome to Privacy Conversations. We have a very interesting conversation today about the Schrems II decision. This is the case of Facebook versus Maximilian Schrems. It's a decision that has been widely anticipated and is finally out. It involves the transfer of personal data between the EU and the United States. And in particular, the decision has some very important holdings for that. One is that the privacy shield mechanism, a special arrangement between the US and the EU to transfer data, that is invalid. So that cannot be used to transfer data between the EU and US. And then it upholds the standard contractual clauses, which is another method of transferring data to the US as well as to other countries. So that is upheld, but with some very important caveats and things of future concern, such as how broadly could these be used? The main issue that the court had with transferring data to the United States is the United States surveillance apparatus and the law's ability in the United States to provide adequate control over that and adequate remedies to people in the EU whose data might be swept up in this surveillance. So I have a really remarkable group of folks that are joining Justin and I. I'm with Justin Antonipillai of Wirewheel, and I'm also joined by Gabriela Zanfir-Fortuna, Bob Litt, and Ralf Sauer. So I'd like to kick it over to you, Justin, to start us off and talk a little bit about your take on this. You worked very closely on and very thoroughly on the Privacy Shield. And so today you've woken up to a lot of your work being completely annihilated. So how does that feel, Justin?
Wow, Dan, what an introduction. First of all, you know, it's great to see you here today, although under very, very tough circumstances in, you know, on the international data transfer front. But I do think it's a very important thing that we have representation and somebody from a leader like Ralf Sauer from the European Commission. And obviously Ralf and Bob Litt and I and Gabriela all worked on the Privacy Shield, all of us. Process. Gabriela at the Article 29 Working Party. Ralf was one of the lead negotiators on Privacy Shield from the Commission. And of course, Bob was the author of the letter that is at the center of most of the analysis of the Schrems II decision. So since most of it, the Schrems II decision turned on Bob's letter, I suppose I could just point to Bob as one of the people who could actually talk about that today. No, but seriously, I'm going to give a quick overview of the decision. And then I really think it's important that we get reactions from the whole group. Now, two things. One, all of us are speaking in our own private capacity, not for our organizations. I know, you know, folks are aligned with different ones. And two, the decision only came out overnight. So we have set up, I know Dan and you and I, another briefing tomorrow, and Ralf and Bob and Gabriela, so that we can take time, actually process it, and see and think about the implications of this decision and bring a deeper analysis to our community. So we have another one tomorrow, and I hope viewers today bear with us, because to be honest, this is a complicated decision, and I think it bears some thought before any of us jump to conclusions. And so when I read the decision, I'll go through my quick reactions of what I saw, and then all of us can go from there. And of course, maybe Ralf, you could talk about in a few minutes what comes next as well. Top line, and I'm going to set aside opinions or, you know, strong reactions to it, but just top line, Privacy Shield has been struck down as a means of transfer of data from the EU to the United States. That is a very, very significant outcome. More than 5,000 companies use Privacy Shield, and my strong sense is that one conclusion has a very strong outcome, especially for small and medium-sized companies who are trying to do the right thing. So that is a very important outcome. A second outcome is the court validated standard contractual clauses as a matter of principle, as a means of transfer. But the court held that a controller who's operating under a standard contractual clause has to make an individual determination about whether the data can be transferred pursuant to a contractual clause to a particular country. And that's an important framing, because it means that even if you have standard contractual clauses in place, there has to be some conclusion that under the standard contractual clause, that when data is moving from Europe to the United States, that you feel like you have the right controls in place for movement to the US, and then of course to other countries. Those to me are, two of the top line holdings that I think are very important. The third one that I think is important is, when does it go into effect? And because this is a matter of fundamental human rights, and because the court concluded that these are the outcomes, the effect of the decision is today. So it's effective today on its terms. And the court did identify, so I guess I'd say in my view is it's effective today, but two things. One, the court in the decision identified the other means of transfer in Article 49 of the GDPR that companies can look to make sure they can continue transferring data. And we'll talk about those. But there is actually precedent, and Gabriela, you can talk about this in terms of what the Article 29 did last time in Safe Harbor, for at least a potential delay in enforcement given the consequences of the Schrems II decision. And obviously we can hope for that as well. So look, I want to broaden the discussion. There's a lot to talk about, but in terms of the core holdings and what I saw when I saw the decision, and we can all react to it momentarily, Dan, that's really what I focused on. I think most companies are now trying to figure out, what do I do next? I think there's a lot to talk about in terms of what's the path next in international discussions. But, with that intro, maybe I'll go around and get your introductions, and then I'll give you a broader one as well. If you don't mind, maybe I'll just going around. Gabriela, start with you, and then Bob, and then Ralph, so that we can all get quick reactions, and back to Dan.
Thank you very much, Justin, and hello everyone to those of you that are logging in and listening to our first quick reactions. I have to say that there has been a storm in my head for the past couple of hours or more, because there are a lot of takeaways and there are a lot of implications of the judgment today. I also have many thoughts about how did we come to this point. And in this regard, I need to mention that, the outcome of the assessment itself of the Privacy Shield, it's not such a big surprise, I think, because if we look at the past cases where the court looked at access to commercial data by government, and that string of cases starts with Digital Rights Ireland, where the court invalidated the data retention directive of the European Union. And then it goes to Tele2's Verige, connected to this data retention case as well. The first Schrems judgment, the EU-Canada PNR opinion. So that was a case concerning, again, international data transfers, but on the PNR into Canada and passenger name records. So there's this entire string of cases where the court took very, very strong positions for the protection of the right to personal data. Now, I think the surprise was that the court didn't take the path that was suggested by the Advocate General, which was that an assessment of the validity of the Privacy Shield is not necessary to solve this particular case. And this is, I think, what caused, some, at least parts of the commotion in the privacy community today. I would say that, Justin, your takeaway is absolutely right also from my point of view, in the sense that standard contractual clauses are a valid means of transferring personal data from the European Union to third countries. Quite interestingly, the court mentions in one of the paragraphs, and I think it's 133, that they are a valid means for transfers independent of the level of protection of personal data in that third country. Very important to mention. But the court also says that in order to achieve the standard needed to ensure lawfulness, with the GDPR and so on, there needs to be, the controller needs to adduce additional safeguards, additional measures to the standard contractual clauses, depending on that level of protection in the third country. And this is where I believe that there's still a possibility to transfer lawfully personal data from the EU to the US, relying on standard contractual clauses and any of the other Article 46 options that we have in the GDPR. It's going to be much more difficult. And a lot of follow-up and assessments would need to be done to see what are these other additional safeguards. Are we talking encryption? Is that feasible? Are we talking about other contractual type of safeguards and so on? But I think we need to recognize that this is, at this point in time, this is not a matter of compliance. And I gave you the point of view from let's say a compliance lawyer, looking at how to have lawfulness ensured for these transfers. I think at this point in time, we can acknowledge that this is a matter of diplomacy, it's a matter of intergovernmental dialogue, and I think it's important to acknowledge that.
Gabriela, that's terrific. I understand where you're coming from that too. So we'll come back to a couple of those points. Bob, tremendous amount of focus in the opinion is on the national security collection and the rights of redress. And obviously the letters that ODNI put together, the ombudsman framework, was determined to not be essentially equivalent to the rights in Europe. And that's one of the holdings of the decision. Reactions to the analysis and any thoughts or quick reflections on where you think this goes next?
Sure. So I think what Gabriela said is true in theory, which is to say, in theory, the court leaves open the possibility that standard contractual clauses could be modified in such a way as to provide protections that overcome the deficiencies that they found in US law. I think as a practical matter, that is going to be very difficult. I can't rule it out, but basically the court found several different kinds of problems with US law that it said meant that that data transferred to the US could not be guaranteed to be protected to the same level as the EU requires. The first set is sort of at the front end of the national security collection process, where they found that, and I'm not going to get into the details of the specific national security programs here, but basically they found that there was insufficient individualized judicial authorization of surveillance, that the surveillance, because it involves in some areas bulk collection, was not proportional, and that it was insufficiently constrained by law. Those are a set of front-end problems. They also found what you might call back-end problems, which is the lack of effective judicial review in the United States. I think that it's possible that there might be solutions found to the front-end problems. Broader use of encryption, perhaps contractual commitments to go to court every time there's a request for data under national security. I think it's going to take some time to sort through whether that's possible. I think the lack of judicial review is a much harder problem because the fundamental defect that U.S. law has here is a constitutional requirement that nobody can bring a lawsuit unless they can show that they have suffered damage. And in an environment where you're talking about national security collection, where people are generally not told that they are the subject of surveillance, a Maximilian Schrems or anybody else is not going to be able to come into court and say, I have been damaged because my data has been turned over to the United States. And because this is a requirement of our Constitution, it's going to be very, very difficult to find a workaround. We spent a lot of time in the Privacy Shield negotiations coming up with the ombudsman as the best possible alternative, and the court has determined that's inadequate. So, while I don't think anybody should throw in the towel yet, I think it's going to take a lot of creative thinking, and maybe not even then will data transfers to the U.S. be able to resume, absent some sort of political resolution between the EU and the U.S. And I think that's where people's attention needs to be focused.
Again, totally agree. So we'll go deeper in a few minutes. I did want to turn to Ralf. Ralf, obviously we worked extensively on these issues, but from the European Commission's point of view, or from the perspective in Europe, any quick reactions to the decision, as of today? And again, I understand this has just happened and we need more time to process. So I understand that there'll be limitations on what you might be able to talk about here today.
Indeed, that's certainly true in a sense, both of the need for maybe a bit of a deeper analysis, because of course I've read it not just one time, but at least 2 times already. But I think it's still a complex judgment that where you need to look at the details. And then certainly in terms of next steps, and obviously that builds on the analysis. But it's also depends on a number of stakeholders and players that need to be involved in that exercise. That involves our U.S. counterparts certainly, but very importantly, under the judgment, also the data protection authorities, which are combined in the European Data Protection Board, and that's particularly true for the application and use of the standard contextual clauses going forward, because it's clear that the judgment poses a lot of responsibility now. First of all, on companies, in particular, actually the EU companies as the data exporter, but then also in the second line, data protection authorities, and I think there are elements there where I would have hoped for a bit more clarity from the court, frankly, and since it's not given, I think it will depend a lot on also the interpretation then and clarification perhaps from the data protection authorities, and I'm particularly thinking about what the court says about taking into account the circumstances of the transfer. That's something which the court stresses in several places when using the SECs and when assessing the question of whether they can be used in the light of the possibility of government access. And then also the additional safeguards, indeed, which are mentioned as something that could complement the standard protection clauses, and what that could be, and how it could address the issues that the judgment raises. So I think there are still points there that need to be further clarified, and I think it's important for companies to give them legal certainty, because they should not be left alone, obviously, with those questions. And this will, as I said, require discussions within the European Data Protection Board. The European Commission is also a member of the board. We participate. We are a non-voting participant, but nevertheless, and we would certainly also bring our views to that debate. But it's first of all for the authorities themselves to think about what to do with the judgment, and they have a big responsibility now. I mean, that's also a consequence. They, in a way, it's maybe what they wish for, that they have more control over data transfers from the EU. But with that sort of power comes responsibility. So I think that's also very clear, and I think it's clear to them, and they will meet tomorrow, and I think then also in the weeks to come, I think there will be a lot of discussions to think about the implications. It's, I think, important also to stress that this is in a way a constitutional assessment by the court. So it's not just what we would call secondary law, so in a way statutory law. It's really all driven by a constitutional interpretation of the Court of Justice, and that's, I think, also something that needs to be taken into account. And of course, it means, well, generally, when I mean, turning to the Privacy Shield, it's our highest court that has taken a constitutional interpretation. So it's something which is very serious. It's something which we take very seriously, and that we need to and will respect, and we'll have to work with the court's requirements. At the same time, we have been in contact with our US counterparts, and this will continue and intensify in the weeks to come to find a solution, because on the one hand, we are very attached to fundamental rights to privacy, and we take note of what the court has told us, and respect that. But of course, we are also interested in facilitating data flows to the US as well as to other countries. And when it comes to the US, we will now discuss these issues. I agree with Bob that it's not an easy task. There are certainly challenges. I would actually have thought that the challenges are maybe a bit bigger even on what Bob called the front end issues when it comes to the limitations to surveillance and surveillance programs. At least my reading at this point, but it's something that I think again needs maybe a bit further analysis, is that the court is not actually requiring that there absolutely has to be judicial redress, but that there has to be redress that is essentially equivalent to that in terms of the independence and impartiality of a body that individuals can turn to, have a right to turn to, and that has the power to resolve their issues. And I think we knew that the ombudsperson was an attempt to achieve that, but that it has its challenges, and I think the court has pointed them out. And I think that's something one needs to work on, but maybe that one can also work on. We'll have to see, of course, what can be done. I think the placement of the ombudsperson was certainly not ideal, if I can put it that way, in the State Department, and the court has pointed that out. And I think also in terms of the powers that it has, and maybe generally also a bit the transparency around that mechanism, because it was the ombudsperson, him or herself, but also together with other independent bodies. I think that's maybe also something that where there's room for improvement, let's say. So that's something we'll focus on. And the important thing is we will not risk, if we go in the direction of, if we would go in the direction of trying a further adequacy decision, we will not take shortcuts. We will not risk the third time an annulment of an adequacy decision with the United States. I think that's or any. I mean, this is not just the United States. It's a more general point. We don't want this to happen again, and therefore, if we do this, and we are open to do it, but it has to be done right and in full compliance on our side with the court's judgment, and so this will certainly require, as Bob said, some thinking and creative thinking if we want to address this. That being said, the inadequacy finding is not the only way to transfer data. Certainly, the use of the SECs also now raises certain questions. But as I said at the beginning, there seem to be some openings in the court's judgment in terms of what can be done in terms of additional safeguards, perhaps, and maybe also taking into account, as I said, the circumstances of the transfer where there is maybe a space to again creatively think about how data can be adequately protected for such transfers. And I think that's all I can say at this point. It's certainly challenging and will keep us busy for some time to come.
Yeah, that's really interesting. I think that, you know, the U.S. has had this a long time coming with I think some very unfortunate jurisprudence by the U.S. Supreme Court. Ultimately, I think the question for the EU is, you know, how strongly to adhere to principle or how to compromise when it comes to being pragmatic and allowing the data to transfer. The biggest problem and the big stumbling block is that a lot of this emerges from the revelations by Snowden about the extensiveness of NSA surveillance. But the US system had long had some severe weaknesses and problems, a lot due to the fact that the Supreme Court had some incredibly, I think, very short-sighted and poor Fourth Amendment decisions, in particular something known as the third-party doctrine, which means that people lack a reasonable expectation of privacy in their personal data if it's in the hands of third parties, which means the government can get it with hardly any protection at all. And you know, law enforcement officials and national security officials aggressively pushed for greater and greater data collection using the third-party doctrine as its big gaping hole in Fourth Amendment protection, because ordinarily there would be protection. The Fourth Amendment would protect if there's a reasonable expectation of privacy. Unfortunately, the Supreme Court left open this door, and that allowed law enforcement and national security officials to do a lot of overreaching. Congress passed a lot of overreaching laws, and we got to a state where it was very difficult to have this type of protection. And then to put fuel on the fire, in 2013, the Supreme Court decides a case called Clapper versus Amnesty International, where a group of people challenged surveillance under the NSA, claiming that they were, NSA was putting them under extensive surveillance and they had to take measures to try to get around the surveillance. And the Supreme Court said they don't even have standing because they can't prove 100% that they were put under surveillance. Now, of course, the irony is the government knew the answer all along. You know, the government's litigating this and they know that they are under surveillance. I presume that they probably were under surveillance given what Snowden revealed. But the government said, we're not going to tell you, but now we're going to go into court and say, because you don't know the answer to the question we already know, you can't even challenge and your constitutional rights. So the court basically, the Supreme Court said, well, we're going to just throw it out, no standing. So it's very hard for people to get redress and to challenge anything with an opinion like that. I think it's a very short-sighted and poor opinion. I hate Clapper. I think it's wrong, but we have it. So we have a bunch of barriers in the law that are very hard to change unless the Supreme Court decides to change that. or we have something at the federal level to address these issues. There's so much companies can do. Obviously, encryption could be a way to perhaps address this issue, and there might be some other means, but it's going to be very, very hard for data controllers and data processors to really protect against what, you know, U.S. surveillance authorities could do in the United States with this information. The third-party doctrine does not respect contract. The fact that you have a contract protecting the data doesn't stop the government from being able to access it. It doesn't kick in a reasonable expectation of privacy. So, you know, I think it would be, I think it's a bad holding that, you know, a contract couldn't give rise to an expectation. But there you have it with the Supreme Court. Now, the court has made a movement to moving away from the rigidity of the third-party doctrine in a case called Carpenter that was decided rather recently. But the court really made baby steps away from that. So we really have a law right now that may be a little bit better after Carpenter, but still very problematic in the U.S. And I think then the question for the EU that I'm really curious about is what do they do? You know, they could really be very, very strict, I think, on principle on this and say, well, you know, we are going to really stick to our guns and you know, demand that there be you know, a much more robust set of protections in the United States, or they'll find some way to allow the transfer of data, but with some sweat. You know, so the U.S. will have to do some things. We'll have to do a bunch of measures. We'll cobble something together that, you know, people will, you know, find at least, you know, messy, not that great, but ultimately acceptable enough to let it go through. You know, kind of, you hold your nose and you do it. And I kind of think that's how, you know, we were under Safe Harbor. I think even under, sorry, Justin, under Privacy Shield, it's a kind of hold your nose situation. We'll try to do something. We'll give a nod to this, but yeah, I'm not sure that either really fully 100% addressed the concerns of the EU. And I think that's what we're seeing. That's at least my take on this. But I think the thing I don't really know is, you know, where will they say, okay, we will accept this compromise? Because I do think there has to be a compromise at this point, because I think, you know, the U.S. law is not going to, you know, dramatically change.
Yeah, and so by the way, Dan, I want to come back to a few of your points. We've had a lot to talk about. Gabriela, I know you have some limitations on time today, and Ralph, I don't know what your windows are too. So I want to turn to both of you next to react. And remember, we're going to be back together tomorrow to go a little deeper on these issues. So we at least wanted to give our viewers and the community a little bit of perspective, quick reactions on the decision. So Gabriela, why don't I turn back to you? And maybe for focus today, we have deeper dives on a lot of these issues today. I mean, tomorrow, I apologize. Obviously, Gabriela, subject to things you want to cover, I might give everybody a chance to say, for today, there's implications for companies that they should think through today, literally today. And then there's going to be some implications or thoughts in terms of how the discussions might go between the US and the EU out of it. And Gabriela, why don't we start with you on any reactions you have? But I think quick reactions that we put it into those two buckets might be helpful. How do companies who are having to react today, what do they really need to focus on today? And then what are your quick reactions from the perspective of the international relationship between Europe and the United States on data?
Quick reaction for today is, for companies, is to look at that. I really like Bob's expression, you know, the front end, right, of this entire situation, and look at the gates that the Court of Justice left cracked open, let's say, with the standard contractual clauses and this additional measures, and with Article 49 derogations. But, you know, and then analyze, for example, the guidelines of the European Data Protection Board on these derogations. And that's an opinion from 2 years ago, if I'm not mistaken, on Article 49. And you have an analysis there. So focus on the front end and identify those possibilities left by the court to be able to transfer data to the extent that you would be able to do so as an immediate reaction. But you know, as for the second bucket of fundamental issues, for me, just listening to you, to Professor Solove, to Robert Litt, you know, just reckoning some of the limitations that are here at constitutional level in the US for privacy, even for American citizens, and it's very important to mention that. It's really it's impressive. And I think just the fact that we are having this conversation right now after the court's decision is already a huge step, you know, in the right direction. And I'm convinced that there is a solution, and we can find a way to figure this out between the EU and the US, because there's just so much that we also have in common in terms of values. And in terms of, well, values, and that's very important. And with that, I'm excusing myself. Unfortunately, I have to drop out, but I'm very eager for our discussion tomorrow after we have had the chance to, you know, let everything sink in a bit.
Gabriela, thank you so much, and we'll look forward to seeing you tomorrow.
So, Justin, if it's okay, I'd like to pose a question to Ralf for him to field. I'm in private practice now. A client calls me up and says, I'm a company. We transfer data from the EU to the US pursuant to a standard contractual clause. What do we do tomorrow?
The good thing is that you're the lawyer, so I'm sure you will give the right advice. As I said, it's at this point not easy to say. There are the issues that the court has pointed out on the privacy shield, since the court now applies the same standard. Which is something which we're also a bit surprised about, but this is how the court has interpreted it. Since it applies the same standard to standard contractual clauses, the findings of the privacy shield are obviously directly relevant also for the use of the SECs. That is clear. But as I said, there are references, and that's only for the SECs because it's a different instrument. It doesn't give, let's say, a blessing to an entire legal system, since it's about the use of a contractual tool with respect to specific data, and it's also a tool, by the way, which is not country specific. That's, I think, why the court has pointed out, and that's something which was also argued before the court, that in using that tool, you can take into account the specific circumstances of the transfer, and I would read this as also to mean maybe the type of data that is transferred. Maybe that is something that could play a role. But also, it has said that there can be additional safeguards. And again, we some things have already been mentioned that maybe one could indeed think about how to protect data beyond what is required by the standard protection clauses. So there might be ways forward, at least for certain types of transfers, and with certain types of additional measures. But that's something which I couldn't at this point be sure what that is, and I think that's why I said there has to be also a discussion among the data protection authorities, because it's their responsibility now also to apply the judgment and enforce it. And consider, because the court has clearly said there's a requirement to suspend transfers or even end transfers if, and then it says, taking into account the circumstances of the transfer and additional measures that might be put in place, the continuity of protection is not ensured. But so it has these two caveats, and I think it's important that the data protection authorities look into this and provide some clarity, develop some guidance of some sort that helps companies and their lawyers to deal with the situation. I'm a couple of hours after the judgment, not in a position to tell you for sure what can be done and what cannot be done. I wanted to say something about. Yeah.
I just want to push back a little bit on this. Do you think that the opinion, which basically says that data exporters and data importers have to assess the validity, the legal regime in the country, do you think that after the CJEU's decision with respect to the US, there is some space for companies to continue to transfer data while they see if there is a mechanism that can be worked out? Or do you think that the court contemplates that all data transfers will cease until somebody works out a better mechanism?
No, I don't think that's so I would think it's the former. So I'm not saying that after making the assessment they can necessarily do so, but it's not that you now have to wait until a new comprehensive mechanism like the Privacy Shield in an improved form, let's say, is in place. It has clearly separated the two instruments. The SECs as a tool for transfers are still there, and actually the mechanism under the SECs for dealing with government access has been blessed. So in terms of the distribution of responsibilities between different actors, data exporter and importer, and data protection authorities. But of course, now you need to then apply it, and it's certainly more difficult now for transfers to the US than maybe for other countries, because the court has, under a different heading, but nevertheless directly relevant also, assessed certain aspects of US law. So that is certainly complicates the situation for transfers to the US. I continue to believe that the solutions have to lie in these two elements: the type of transfer, the context of the transfer, and additional safeguards. I think whether that can address all the issues that have been pointed out, I think remains to be seen, and it's something that ultimately the data protection authorities will have to decide. I wanted to say something on the on two things. On one thing is on the derogations. It's again not entirely clear to me what the court has decided on the derogation. So I mean, maybe for the audience, not everybody might know these terms. Our data protection rules, the General Data Protection Regulation, contains, let's say, a list of statutory grounds for data transfers. And that's what we call the derogations, because they are sort of in the absence of an adequacy finding, such as the Privacy Shield decision, or appropriate safeguards. And there's one place in the judgment where indeed the court seems to signal that maybe these could, namely when deciding on whether or not there is a need to sort of grant a grace period. The court was asked to do that and made a decision at the very end of the judgment on this. And in this context, it indeed refers, I mean, it says there is no need in a way for a grace period because there are still the derogations. So that could be read as suggesting that for this transfer tool, the requirements laid out in the judgment do not apply. At the same time, there's other parts of the judgment which I think put this a bit into question. So it's not entirely clear. Will also, I think, require some discussions what this means for the derogations. But the important thing is that, of course, they have their inherent limitations. It was already pointed out that there are guidelines on these derogations that say, for example, that you cannot use them for massive sort of structural repetitive data transfers. So they have their inherent limitations, and I would actually, frankly, hope that I mean, it's if you look at the whole context of the judgment, it would be ironic if we would now go in the direction of using things like consent, for example, without then further safeguards. If that was what some people maybe have in mind when referring to the derogation. So we need to be careful that there's a meaning to what the court has decided and what it wants to achieve. And then the last point I wanted to make is on redress, because I mean not to that I am gotten wrong. I think that the court, because it analyzes the ombudsperson mechanism, I think it wouldn't have done that, I believe, if it wouldn't consider that in the area of national security, there is maybe not always a need for a court necessarily to provide redress, but there has to be nevertheless a body or bodies, several that are sort of provide an essentially equivalent level of protection in terms of their independence from the executive and their impartiality. And I think that's the important element here. I mean, I guess whenever we are talking about redress, it's somehow clear that there has to be, I mean, that redress mechanism, it must be absolutely certain that it's not influenced by the ones that it's supposed to control. And that is the executive in the end. So I think that's the difficulty that we're facing. But I know about the discussions, we looked at this in detail, that Daniel has described, and we are certainly in favor of judicial redress in this area. But I know that this is a domestic discussion that you're also having, and it would probably indeed be helpful if, in terms of individual notification of people at some point when there's no longer a risk to an investigation, that this takes place and that this addresses the standing issue that arises, I think, in U.S. courts. So that's certainly also something which I think is something one should consider. But it's ultimately, I'm not the U.S. government, I'm not a U.S. citizen, but it's something that I think is probably worthwhile considering, not just for foreigners, but also for U.S. citizens, because the same problem arises there.
So, Ralf, I'm going to follow up on just a couple of things for everybody. And I know we wanted to do this for about an hour today, and we're going to be back tomorrow. So I'm going to focus on just a couple of things that I know are critical. One is Privacy Shield companies today. There are 5,000 plus Privacy Shield companies trying to do the right thing. Ralf, have certified. I think the guidance for today, just for today, they've lost a mean of transfer. They have to do business. That's a critical element. What I take from the decision is, by the way, Dan, I think Bob had to be let back in. But for today, I would read the paragraph of the decision right above the costs section, just to be specific, because Ralf and Bob and I and Dan are all talking about the same thing. It basically says, look to Article 49, which covers the derogations. Look to that section and see if you can have coverage under a derogation. And I think we should probably talk about this tomorrow, because Ralf, I've read that paragraph now 5 times. I have a very hard time focusing on what the court was trying to communicate in that paragraph around Article 49, because it seemed to be giving some guidance, but it's hard to fully process. And so for Privacy Shield companies, I think your answer is to look at Article 49 per the guidance of that and see if there's some way you can continue to do business today until there's guidance from the DPAs about what happens, because there is a group of companies that have an urgent issue today. So that's probably number one. And I'll get everybody's reaction. Under standard contractual clauses, there's a lot to process. I think one thing, Ralf and Bob and Dan, is, even today, there's a press release from the Irish DPA, and the sentence says although the court has ruled that SEC's transfer mechanisms used to transfer data to countries worldwide is in principle valid, although it is clear that in practice, the application of the SEC's transfer mechanisms to transfers of personal data to the US is now questionable. That's the DPA making the statement today. That's very much in the vein of what Bob and myself and Dan, I think, Ralph, we're all trying to process, which is if you're under an SCC and you're transferring data to the US, in light of the decision that the court read, what do you do, either for front end, as Bob called it, or as, like what kind of controls legally or technically do you put in place so that you can continue transferring data in light of the opinion? That's, to me, is the core question. And you have the Irish DPA today issuing a release, even where the EDP, the European Data Protection Board, is issuing guidance. So that's very difficult for companies, candidly, to process. What are we supposed to do with that?
And let me just say that I think that the idea that the derogations can substitute for Privacy Shield or the standard contractual clauses is an utterly unrealistic figment. The derogations can't possibly be used on the scale and for the purposes for which companies transfer data today.
Well, that's my reaction, honestly, too, which is the whole point of adequacy was that you're not using derogations in that way. That's why I'm having a difficult time, Ralph, but you were saying it too. I don't understand the paragraph, candidly. And I think we can talk about this tomorrow, but you have companies that are literally, there's all kinds of situations and you have to react today. I think it's very difficult to process those two tensions. What do you do if you're a Privacy Shield company, and how do you deal with that derogations paragraph? And as an SEC covered company, how do you interpret and put either protections legally or technically consistent with the language of the opinion and in light of what the Irish DPA is issuing? And then finally, for me, for discussion tomorrow, there are things that we should talk about, I think, and maybe a longer conversation around what Bob and you, Ralph, have been talking about. Like, where do you go next in international conversations? But this is in some ways, and I agree totally with Dan. I've been very worried about the third-party doctrine. There's the ECPA. We have a lot we could talk about, but this is a balance of constitutions that we're in. This isn't like an abstract thing. In the U.S., you have a constitutional provision around a constitutional set of principles around standing that have been interpreted by the Supreme Court to require certain things before a human being in the U.S. can bring a case in controversy, under the standing requirements. That's an impediment, no matter what you want to do as a statutory matter. We have to talk about that. Number two, Ralph, we talked about this at length, but there are appointment clauses. It's the appointment clause. As you're one of the greatest. You're for the depth that Ralph has on the appointments clause. You could write a constitutional treatise. I know we've talked about this. There's an appointments clause issue in the U.S. Constitution around appointing somebody to serve as an overseer in an independent way. That's complicated, and I don't want to skirt around it. You can't just sort of declare somebody independent from the executive. Who appoints them? How do they do it? And I think the ombudsperson was a very thoughtful exercise when you complement it with the inspector generals and other things. So it wasn't just the ombudsperson that was as part of the process. So I think there is more to talk about on the international data transfer front. Obviously, this is a vindication of the fundamental human right of privacy, and I don't think any of us want to ignore that, right? That is an important principle, and I think there's some nuance to these things that we should try to cover tomorrow. So anyway, quick last reactions around for today, either for companies or on the next steps, and we obviously could pick this up tomorrow.
Yeah. I think on the derogations we talked about it. No, I mean, just to say, I was exactly not suggesting that I'm absolutely sure about the provision that you point to, because, as I said, there's other parts of the judgment, and I think I'm talking about paragraph 92 of the judgment, which also suggests that the general rule of continuity of protection is something that applies to any transfer tool, and that would include the derogation. So that's why I'm actually not entirely sure what the court is saying, although I would grant that the last paragraph, as I said, seems to suggest that is possibly something that you can use, but it has a lot of limitations. And in that sense, I totally agree with Bob that it's certainly not the same as an adequacy finding. There's no question about this. It has clear limitations, whereas adequacy in principle gives the free flow of data to another country. So that's certainly true. I cannot tell you right now how the SECs can be applied. I would have hoped that the Irish DPC would have waited for the meeting of the EDPB, but of course you also have to understand them. The court came from Ireland. It came from the Irish High Court, and based on a case brought by the Irish DPC. So obviously they could not stay silent on a case which is their case with respect to Facebook. So but I wouldn't read what they said as saying there's no way that you can use SECs. I think they correctly say that the SECs are valid, but there are now questions about the use of them. And I think, but questions does not mean that there are no possibilities to use them. And I refer to maybe the openings in the judgment, which maybe can provide the entry for some solutions in terms of security or other that could help. But that remains to be seen. And lastly, we totally know about that standing is something, and the standing doctrine is something which is an interpretation of the Constitution, and it has its foundation in the Constitution. But I was just saying that if you would notify individuals at some point that their data has been accessed, then you can show that you are individually concerned, or that there is injury in fact, and that could help you to show a standing. So it would be within the system, but you, of course, to get there, that was always the problem for Wikimedia and others or Amnesty International to get there, because they couldn't show that they were concerned by surveillance. And on the appointment clause, and I guess what you mean is that it's difficult to create fully independent bodies or persons that cannot be, for example, removed from office by the president. We are aware that there are also constitutional limitations, but I think between that and putting the ombudsperson into the State Department, I think you will acknowledge that there's still there might be still room for maneuver.
Yeah. No, there is a path. I think there is a path where you can have that conversation, Ralf, but it's not easy, you know.
It's not easy, that's for sure.
Dan, Bob, before we wrap up today.
My only final comment was going to be, I think there's a path to a conversation. I'm a lot less certain that there's a path to a solution.
Yeah, I have that worry too. And when you get down, I've seen a lot of folks keep writing SCCs are still valid for transfers to the US. Somebody has to make a judgment and write a piece of paper that says we're okay. That's a tough row to hoe today, you know, when you're doing it. So Bob, when you get some of those opinions written, if you could share them with us, that would be great. Dan, any final reactions?
Yeah, well, I think that ultimately, I think just, you know, pragmatism will win out. There'll be some ability to compromise, some way to muddle through it. I think that, you know, the court left open that door with the SCC. And then the question is, how will the muddle be? I don't think it's going to be pretty, but there'll be some way to cobble together a solution for this, because I find it surprising that, you know, essentially you would not be able to transfer data from the EU to a whole host of other countries, China, UK, and others. So I think there just has to be some way out of this. And I think the court has kind of left that door open deliberately and somewhat, I think, deliberately vaguely, so that there would be something. So I think this will go on for a long time, but ultimately I think that there'll be a door, and it will be ambiguous for probably a while. But my take on it was probably maybe that was purposeful, to let this continue and while we keep sorting this out, because I don't think there is a perfect answer. We just have to be messy.
Can you imagine briefing the president on this decision today? You guys want to write that position paper? Well, look, there's a lot to talk about. I look forward to talking to everybody tomorrow. Ralf, thanks so much for joining on short notice. It's incredibly valuable to have you take a break, I know, in the middle of a very busy day, and to share with the community at least your quick reactions. And Dan, always great to have our conversation. And Bob and Ralf, look forward to speaking with you tomorrow.
Thanks so much for joining us.
Thanks, Justin. Thanks, Dan. Ralf.
Thank you all. Bye.
Have a good day. Bye-bye.